Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, any views and opinions expressed in this podcast are those of the podcast creator alone and do not reflect or represent the views, positions, or policies of any organization, institution, or entity, past, present, or future, with which the creator is or may be affiliated.
Welcome to the Deep Dive. Today we're getting into a really significant legal source, a single judgment from the High Court of Delhi. It involves some pretty advanced biotech, specifically cancer detection, bumping up against some long-standing patent law exclusions in India. Our mission here is to unpack this one high-profile case, Natera Inc. versus the Patent Office, by tackling about 11 specific questions. The aim is to give you a really solid grasp of what this means for medical innovation.
Yeah, and the core tension here is fascinating. You've got this very sophisticated, non-invasive lab method for finding cancer mutations. Super advanced stuff. But the big question was, can you actually patent that process in India? Or does it fall foul of Section 3I of the Patents Act, the bit that says you can't patent methods of diagnosis? This judgment, well, it really draws a line in the sand.
Okay, so let's start setting the scene. This is about a patent application called Methods for Lung Cancer Detection. The appellants were Natera Inc. and UCL Business Ltd., fighting a refusal by the Assistant Controller of Patents and Designs.
Right. And to really get into it, we need those basic case details first. Q1 on our list.
Exactly. So what are the essentials? Case number, court.
Okay, so the case number is CACOMM.IPD-PT 16-2023. It's from the High Court of Delhi at New Delhi.
Delhi High Court. Got it. And the date.
The judgment was pronounced on October 9th, 2025. And the judge was Justice Pratibha M. Singh.
Single judge bench then. And the parties. You mentioned Natera.
Yep, Natera Inc. They're a clinical genetics company out of California, a big player. And UCL Business Ltd., which is involved in knowledge transfer in the UK. They were the appellants.
And opposing them.
The respondent was the Assistant Controller of Patents and Designs. Basically the Patent Office.
And there was also an amicus curiae involved, wasn't there? Mr. Adarsh Ramanujan.
That's right. His appointment really highlights how important the court saw the interpretation of Section 3I. Getting that diagnostic exclusion right was clearly seen as critical.
Okay, that covers the who, where, and when. Let's move to Q2. The key facts and the timeline. What exactly was this invention about?
So the patent application number was 2181703321 cent. The invention itself was described as a non-invasive in vitro method. So done in a lab, not on the patient directly.
In vitro, right. Using what kind of sample?
Using a blood sample. The idea was to isolate cell-free nucleic acid, cfDNA, basically tiny bits of DNA floating in the blood, and then use multiplex PCR, polymerase chain reaction, to look for specific genetic markers.
Markers for what specifically?
They were targeting single nucleotide variants, or SNVs, linked to lung squamous cell carcinoma. That's a specific type of non-small cell lung cancer, NSCLC. The goal was detection and tracking.
And it sounds like it was incredibly sensitive technology.
Extremely. They claimed it could detect circulating tumor DNA down to a 0.01% variable level. But despite that sophistication, the Patent Office refused it initially.
When was that initial refusal?
That was back on March 20, 2023. And the refusal hit 2 points. Claims 1 to 4 were rejected under Section 3I, the diagnostic method exclusion.
Okay. The main issue we're discussing, what was the second point?
Claims 5 to 8 were rejected under Section 59, which deals with amendments to patent claims. They basically said the changes Natera made weren't allowable.
So 2 distinct grounds for refusal initially, which leads us to Q3. The core legal issues the High Court had to grapple with on appeal.
Well, there were primarily 2 big ones. First, defining the actual scope of Section 3I. Just how far does that exclusion for diagnostic methods reach in Indian law?
Does it just cover a doctor making a bedside diagnosis, or does it include complex lab tests too?
Exactly. And second, based on that definition, did Natera's specific PCR method actually fall within that exclusion? Was it truly a method of diagnosis under the Act?
And the Section 59 amendment issue.
That was also technically before the court, but as it turned out, the judge found the Section 3I point was enough to decide the case. So they didn't actually rule definitively on the amendment issue in the end.
Right, it became moot once 3I was decided. Okay, let's dig into the arguments. Q4. What was Natera's main line of reasoning? How did they argue this wasn't diagnosis?
Their core argument was definitional. They insisted their method didn't provide a definitive diagnosis. They stressed it was used on patients already suspected of having NSCLC.
So not the initial screening, but more of a refinement step.
Kind of. They framed it as identifying the type of SNV present using their special PCR technique. They argued this was more akin to research, or maybe predisposition testing, rather than the final diagnostic call that leads directly to treatment.
Did they rely on any specific definitions or past cases?
Yes, they pointed to a Madras High Court judgment arguing that diagnostic should be narrowly interpreted to mean only processes that reveal pathology specifically for treating a person.
Trying to limit it quite significantly there. And what about the amended claims, claims 5-8?
On the Section 59 point, they argued those later claims were actually supported by the original international PCT application claims, specifically claims 41, 42, 43, 47, and 52, and so the amendment should have been allowed.
Okay, that's Natera's position. Now for Q5. How did the Patent Office push back? What were their counter-arguments?
The Patent Office basically said, hold on a minute. They argued, Claim 1 itself clearly involves a determination step for SNVs linked to tumors. That sounds like diagnosis.
They pointed to the claim language itself.
Yes, and even more powerfully, they pointed back at Natera's own description in the patent specification. Natera themselves had written that the methods improve the detection, diagnosis, staging, screening, treatment, and management of lung cancer.
Using the D word themselves, that's usually not helpful when arguing it isn't diagnosis.
Precisely. Hard to walk that back. And on the in vitro point, the fact it happens in a lab.
Yeah, Natera must have leaned on that distinction, that it wasn't practiced on the human body.
They did, but the Patent Office countered that Section 3I makes absolutely no distinction between in vivo and in vitro methods. The law just says any process for the diagnostic treatment of human beings. Full stop.
So the location of the process lab bench versus bedside was irrelevant in their view.
Completely irrelevant, according to the Patent Office. They argued that if you allowed in vitro methods to be patented just because they were in vitro, you'd essentially gut Section 3I for most modern diagnostic technologies.
And what about the Section 59 amendment argument?
They opposed that too. They basically said, look, the applicant voluntarily amended their claims during prosecution, specifically disclaiming a whole bunch of original claims. The Patent Office can't be expected to just revert back to old PCT claims that the applicant themselves abandoned.
Okay, so strong counterarguments across the board. This brings us to the judgment itself. Q6. What was the final decision? What did Justice Singh hold?
The bottom line, the appeal was dismissed. The High Court upheld the refusal, finding that Natera's invention was indeed hit by Section 3I of the Patents Act.
So definitively non-patentable as a diagnostic method.
Yes, and because the Section 3I objection was dispositive, meaning it settled the matter, the court explicitly stated it didn't need to go into the other potential issues like inventive step or the Section 59 amendment problem.
Understood. Now for the crucial part, Q7, the court's reasoning. Why did Justice Singh conclude this advanced lab-based technique was non-patentable diagnosis? Let's really analyze this.
The court started with the fundamental purpose of Section 3I. It framed it as a public policy exclusion.
Public policy? In what sense?
In the sense of protecting the autonomy of the medical profession. The idea is that doctors, nurses, paramedics, they need to be free to use their skills, their knowledge, the process of figuring out what's wrong with a patient without worrying about stepping on someone's patent.
So it's about ensuring clinical freedom for core medical tasks.
Exactly. And based on that public policy goal, the court rejected Natera's attempt to narrow the definition of diagnosis.
The argument that it had to be definitive or identify the exact cause for treatment.
Right. The court said no, diagnosis isn't just about the final conclusive discovery. It's the whole process of getting information about whether a condition exists or its stage. For example, determining if someone has stage 1A, 1B, or 2A squamous cell carcinoma, that is a diagnosis, even if further steps follow.
Okay, but what about the in vitro versus in vivo distinction? That seems like a major technical point. How did the court handle that?
This was a really deep part of the analysis.
Yeah.
The court looked closely at the legislative history in India, including the Iyengar Committee report, which predates the act. They also compared India's law to international standards, specifically TRIPS Article 27.3a and the European Patent Convention, EPC.
And what did that comparison show?
It showed a critical difference. The EPC explicitly excludes diagnostic methods practiced on the human or animal body. That specific phrase is why purely in vitro tests can be patented in Europe.
Ah, so the European law has that specific limitation built in.
Yes, but, and this is the key, finding the Indian statute, Section 3I, and the relevant TRIPS provision do not contain that limiting phrase practiced on the human or animal body.
So the court interpreted that omission as deliberate.
Absolutely. They concluded that the Indian Parliament consciously chose not to limit the exclusion to only in vivo methods. Therefore, Section 3I applies equally to both in vivo and in vitro diagnostic processes in India.
That's a huge clarification. It firmly places lab-based diagnostic methods under the exclusion.
It does. Then the court drew another important line. The difference between a diagnostic process and a diagnostic product.
Okay, explain that distinction.
They said tools, devices, kits, reagents. The products used in diagnosis are potentially patentable if they meet the usual criteria like novelty and inventive step. Think a new type of scanner or a novel antibody for a test kit.
So the physical thing can be patented.
Right. But the process or the method that a medical professional employs using those tools to actually arrive at a diagnostic conclusion, that process is excluded by Section 3I.
And Natera's invention was clearly framed as a process, a method.
Unmistakably. It was claimed as methods for lung cancer detection. The court found it was squarely aimed at the process of diagnosing and detecting the cancer, not just providing a tool.
Did they mention Natera's own description again?
They did. They referenced the Novartis Supreme Court judgment, which warned against artful drafting, trying to disguise the true nature of an invention. The court felt Natera's complete specification, stating the goal was to improve detection, diagnosis, staging, confirmed the true purpose fell within the diagnostic exclusion.
So the reasoning seems quite layered. Public policy, definition of diagnosis, legislative intent on in vitro in vivo, and the process versus product distinction. What about Q8 and Q9 precedents and opinions? Did the court lean heavily on specific past cases?
Yes, definitely. For defining the multi-step nature of diagnosis data collection, comparison, finding deviation, deductive decision, they explicitly relied on the interpretation from a key European Patent Office case, G0000104.
Interesting. They used an EPO case for defining a term in Indian law.
Well, it helps structure the understanding of what constitutes a diagnostic process. And as mentioned, they also cited the Indian Supreme Court's Novartis decision regarding claim drafting and avoiding exclusions through clever wording.
Okay. And Q9, was there any dissenting or concurring opinion?
No, as it was a single-judge bench under Justice Pratibha M. Singh, there was just the one main judgment, no separate opinions.
Right. So pulling back to the bigger picture, Q10, what's the real legal significance or precedential value of this Natera decision?
I think it offers definitive clarity on a previously somewhat ambiguous area. It clearly states that in India, a method of diagnosis is excluded even if it's a highly technical, non-invasive in vitro process done entirely in a lab.
So it solidifies India's distinct path compared to places like Europe or the US.
Absolutely. It formalizes a significant barrier for patenting diagnostic methods originating from jurisdictions where such processes might be patentable. It sends a clear signal about India's approach to balancing healthcare access and biotech innovation in this specific area.
And the court itself acknowledged this might impact innovation.
It did. Justice Singh explicitly raised a concern that the ambiguity and perhaps the breadth of Section 3I might hinder innovation. There was even a suggestion that maybe the legislature should revisit it given technological advances.
But the court felt bound by the current law.
Exactly. The judgment stated that the court's job was to interpret the statute as it stands, not to rewrite it based on policy preferences. Any change would have to come from Parliament.
Okay, we started with this cutting-edge cancer test and ended up deep in the interpretation of a 50-year-old law. Fascinating journey. Let's get to Q11, the single most important key takeaway from this judgment. What should listeners really lock onto?
For me, the crucial principle establishes this. In Indian patent law, the exclusion for diagnostic methods under Section 3I applies broadly to the process of diagnosing. It doesn't matter where that process happens in the lab or on the body. If the outcome of your claimed process gives a result that can be clearly interpreted by a medical professional regarding the presence, absence, or stage of a disease, then that process itself is likely non-patentable in India. It hinges on whether the process contributes directly to the diagnostic reasoning chain.
That's a very clear takeaway. The process informing medical interpretation is the key. Now, for that final provocative thought you mentioned earlier, building on the court's mention of AI.
Right. The judgment reiterates that the law excludes the process used by the medical practitioner. But think about the rise of AI and sophisticated algorithms, maybe even LLMs, in diagnostics, as the court noted. These tools can analyze vast amounts of data, like the sequencing data from Natera's test, and might even propose a diagnosis. Now, the final call still rests with a human clinician. But if the AI does 99% of the analytical heavy lifting, essentially performing the core process that leads to the result, how long can the current definition of a non-patentable process of diagnosis hold up?
You're asking if the technology itself is blurring the line between a patentable tool and a non-patentable diagnostic process.
Precisely. Will the increasing sophistication of AI in interpreting complex biological data force the legislature to eventually refine Section 3I? Will they need to draw new lines distinguishing the non-patentable final clinical judgment from the potentially patentable advanced technological processes that inform that judgment? That's the big question this case leaves hanging for the future.
A very pertinent question indeed, especially given the pace of AI development in healthcare. This has been a really thorough, deep dive into the Natera judgment. Thanks for breaking down the source material so clearly.
Happy to do it. And I'd really encourage listeners, if you're interested, to explore the broader public policy debates around these patent exclusions. It tells you a lot about how different systems try to balance innovation, access, and professional practice, especially in rapidly evolving fields like biotech.
Absolutely. Well, that's all we have time for on this deep dive. Thanks for joining us. We'll see you next time.
Thanks for tuning in to the full episode. If there's any topic or case law you'd like us to cover next, share your suggestion in the comments on our latest video. And if you found value in the podcast, don't forget to like, subscribe, and hit the bell icon to stay updated.